Hello, welcome everyone. Welcome. This is the National Criminal Law Lecture. My name is Chad Norrell. I'm a clinical professor of law at Arizona State University. And let me give you my email address. In case you have any questions about today's lecture, you can email me. I typically don't answer questions about any kind of MBE questions or multiple choice questions because I didn't write those. But if you have questions about my lecture today, feel free to give me a shout by email. That email is my name separated by a dot. It's chad.norrell, it's chad.norreuil @asu.edu. So as for criminal law content on the bar, I think as most of you probably know, essentially for the MBE they combine criminal law and criminal procedure into one subject. So there's approximately 17 MBE or multiple choice questions for both. And today we're going to look at some of the ways they test you in criminal law as far as the MBE is concerned. We're also going to look at some of the things that they typically test for essays as far as criminal law goes. I mean, my purpose today is twofold. To point out some of these key concepts that are most often tested, but also my purpose today is to help you actually get started learning these concepts. So today is not just a means to an end. You can actually have some foundation of knowledge before you leave here, and hopefully that will be the case. Hey, I know it's tough. I know it's a drag. I know it can be a burden, and I know there's a lot of stress going on. So our mantra for today is, whatever it takes. Whatever it takes. Now, I'm not talking about going all Tanya Harding and all of your classmates, so you're the only one left taking the exam and therefore will pass. I'm not talking about that. I mean, at least not yet. We'll see how studying goes for a while, and we'll put it in the back of our mind. I'm talking about whatever it takes to be engaged in order to learn the material, in order to pass the bar exam. So I'm going to bring everything I have today, every ounce of energy, try and help you guys get started learning this stuff so you can pass, whatever it takes. So, off we go. Roman numeral 1. Jurisdiction and general matters. If you get tested anything here, it's probably going to come from our Rule A. A state acquires jurisdiction over a crime if either the conduct or the result happen in that state. The conduct or the result. Best illustrated by hypo number 1. Jay, staying in California, shoots a high-powered rifle across state lines into Arizona and kills someone. Question: which state has jurisdiction over the crime? Answer: both. Both. California, because the conduct occurred there. Standing, California. California because the conduct occurred there, and Arizona because the result happened there. And Arizona because the result happened there. Again, have jurisdiction, conduct, or result. And I think most of you probably know this, but just because you're a citizen of Arizona, if you travel to New York and you commit a crime, the state of Arizona has no jurisdiction over that crime. The state of New York would have jurisdiction because that happened in that state. So by virtue of your citizenship, that doesn't matter. So conduct or result, kind of a rule. B, merger. Generally, there is no merger crimes in American law. What does this mean? Generally speaking, it means if you commit two crimes, generally speaking, you can be charged and properly convicted of both of those crimes, because one crime does not become or merge into the other. 2, but, big but, solicitation and attempt. But solicitation and attempt do merge in the substantive offense. Thus, if you've completed that crime, you cannot be convicted of attempting to commit the crime. Solicitation and attempt do merge the substantive offense. Thus, if you've completed the crime, you cannot be charged, convicted of attempting to commit the crime. 3, note, often tested on the MBE, conspiracy, the third or 3 inchoate offenses along with solicitation and attempt. Conspiracy does not merge in the substantive offense. Thus you can, C-A-N, can, be convicted of conspiring to do something and doing it. Again, conspiracy does not merge in the substantive offense, often tested on the MBE. Roman numeral 2, essential elements of a crime. What do we need for criminal liability? First, we need an act, or actus reus. We need an act. For criminal liability, there must be an act. Bad thoughts alone, not enough to constitute a crime. Probably a good thing for all of you as you're going through the bar exam process right now. So let's talk about an act. A1. An act can be any bodily movement. Any bodily movement. But the act must be a voluntary act. The act must be a voluntary act. 2, double stars on 2. Now, double stars is going to be my shorthand for the rest of today. It means this is often tested on the MBE. If I say double stars, something we have to know because it shows up again and again and again on the MBE. Roman numeral 2, examples of bodily movements that do not qualify for criminal liability. A, conduct which is not the product of your own volition. Conduct which is not the product of your own volition. B, such as a reflexive or convulsive act. A reflexive or convulsive act. Big example here, having a seizure. If someone's having a seizure, arms might be flailing, pop someone in the mouth. That's not going to give rise to criminal liability. Why? Because it wasn't a voluntary act. And C, they love this one on the MBE, an act performed while you are unconscious or asleep. An act performed while you are unconscious or asleep. Big example to look out for here is sleepwalking. If someone's truly sleepwalking, the acts they perform while sleepwalking are not going to be voluntary acts and therefore not going to give rise to criminal liability. Which jumps us to hypo number 2. You're standing waiting for a bus when someone pushes you into a third person, who then falls in front of the bus, is run over and killed. Would you be held criminally liable in this situation? Answer, no. Why not? Because you were pushed, which is not a voluntary act. Again, answer here, no. Why not? Because you were pushed, and that is not a voluntary act. Again, we must have a voluntary act for criminal liability. It cannot be reflexive or convulsive. Watch out for that. Watch out for someone having a seizure. Watch out for the sleepwalking. But B, sometimes an omission can constitute an act for purposes of criminal liability. So generally, there is no legal duty to rescue. Generally speaking, no legal duty to rescue. But sometimes there's a legal duty to act. No legal duty to rescue, generally speaking, but sometimes there is a legal duty to act. And the legal duty to act can arise in one of 5 circumstances, and here they are. 1, by statute. Big example here, the requirement to file your tax returns. If you fail to do so, that failure can constitute the act for purposes of criminal liability. It's an omission constituting an act. Requirement to file your tax returns. B, by contract. Example here, a lifeguard or a nurse has a legal duty to act. A lifeguard or a nurse, and of course, what I mean here is a lifeguard or a nurse who's actually on duty. They sign that contract for their job that they would in fact act. We're not talking about off-duty, we're talking about on-duty lifeguard or nurse. 3, not often tested, but just so we know, because of the relationship between the parties, example here, sometimes a parent's duty to protect children or a spouse's duty to protect the other spouse. And 4, double stars here, because you voluntarily assume a duty of care, and then fail to adequately perform it. Because you voluntarily assume a duty of care and then fail to adequately perform it. MBE loves number 4, which jumps us to hypo number 3. Hypo number 3. Shaq has a party on the lake at his lake lot. Suddenly, everyone notices a man flailing in the lake as if he's about to drown. Shaq tells everyone that he'll save the man, and he dives into the lake. Shaq swims out to the man and sees the drowning man is Kobe. Kobe says, "Help, all my championship rings are weighing me down and I'm drowning." Shaq says, "That's terrible. That's terrible. Hasta la vista, Kobe." And then swims back. Question: if Kobe drowns, does Shaq have any criminal liability here? Answer: yes. Why? Because he assumed a duty of care. I'll save him. And then failed to adequately perform it. Can answer yes. Why? Because he assumed a duty of care and then failed to adequately perform it. And guys, as a corollary to this point, there's a little bit of space if you kind of want to write this example in. If I change this hypothetical here, and instead Shaq looks out and recognizes that it's Kobe, and then doesn't do anything, but instead he just takes tremendous joy in Kobe's demise. If he's there and he's laughing, ah ha ha ha, he's even cheering, Kobe's gonna go down, Kobe's going down. No criminal liability in that situation, because he didn't voluntarily assume a duty of care. So watch out for that. Someone laughing and taking great pleasure in someone else's demise. They toy with your emotions a lot in the exam. It seems as if that's wrong, but nonetheless, you don't assume that duty of care, then there's going to be no criminal liability. Which brings us to number 5 on our list of omissions, constituting an act for purposes of criminal liability. They love this one too. Number 5, where your conduct created the peril. Where your conduct created the peril. Which jumps us to hypo number 4. Dr. Evil has a pool party and is showing off his fancy new laser pointer, which I like to call it a laser. Laser. I know, no one does Austin Powers jokes in like the last decade, but I really like saying laser. Whatever it takes, people. Whatever it takes to be here. He flashes the laser pointer in Austin's eyes, and Austin falls into the pool. Austin cannot swim, and Dr. Evil decides to laugh rather than do anything to save Austin. Question: will Dr. Evil face any criminal liability in this situation? Answer: yes. Why? Because his conduct created the peril, and he did not act. He's got to do something in this situation. If he can't swim, then he's at least got to go try and get a life preserver, go ahead and call someone who can swim. He's got to do something if it's his conduct that created the peril. Watch out for this on the exam because they love this one, and it's usually in the form of having someone go into the water because it's their fault. Pushing someone in, the laser pointer, watch out for that. All right, guys, quick review. Ground, criminal liability, what we need an act. Sometimes an omission can be an act. What else do we need? We need a mental state, right? Mens rea. Which jumps up to C, mental states. The only time today I'm going to say triple stars on mental states. Triple stars. And I know you all have vast powers of deductive reasoning after 3 years of law school, so you know that 3 stars more than 2 stars, so this is very important. Absolutely, positively guaranteed to be on the MBE. Always, always, always. In fact, multiple questions on the MBE for criminal law on mental states. So let's jump into it. There are 4 common law mental states of crime. 1, there are specific intent crimes. 2, malice crimes. 3, general intent crimes. And 4, strict liability crimes. Let's talk about each one. First, 1, specific intent crimes. The importance of specific intent crimes is that they will qualify for additional defenses. Additional defenses. Not available for other types of crime. We'll talk about these additional defenses more in depth later, but if you're one of those type A law student personalities just has to know what these additional defenses are, you can go ahead and write this in the little space there provided. The two additional defenses, voluntary intoxication and unreasonable mistake of fact, are two additional defenses. Voluntary intoxication, unreasonable mistake of fact. All right, guys, look, we just have to memorize the specific intent crimes because on the exam, they're not going to tell you, oh, and by the way, this is a specific intent crime. We have a list. We have to memorize it. Now let's jump into it. Our specific intent crimes, A, B, and C, these were our code offenses we talked about a little bit earlier, solicitation, conspiracy, attempt. And then D, we have first-degree murder. We see here there's a period at the end of first-degree murder. That's actually not a typo. What's the period mean? Stop, pause. So let's all pause for just a second. This is a non-note-taking moment. I'm going to cover this a little bit later on, but I want to sink in right now. So if on the exam, on the MB, you see the word murder, and it's just hanging out by itself, just says murder, very important point here, guys. What they mean is common law murder, which we commonly refer to today as second-degree murder. So if you just see the word murder, that means it's not a specific intent crime because only first-degree murder is a specific intent crime. Very, very important point because they're not going to tell you. We need to make sure we know that. See the word murder. What's that mean? It means common law murder, which is not a specific intent crime. Okay, back to our list. Assault, larceny, embezzlement, false pretenses, robbery, burglary, and forgery. All crimes are specific intent crimes, all crimes that we're going to talk about a little bit in depth today. So we have to memorize what these specific intent crimes are. Here's a little mnemonic. This is mine. You can use your own, whatever it is. You got to make sure you know what they are. Specific intent crime mnemonic. Students can always fake a laugh, even for ridiculous bar facts. Students, solicitation, can always, conspiracy, attempt, fake a laugh, first-degree murder, assault, larceny, even for ridiculous bar facts, and so forth down the line. So I think this is a good mnemonic because it is something that you should take to heart because you can't always fake a laugh, and there will be ridiculous bar facts at some point in time. Students can always fake a laugh, even for ridiculous bar facts, specific intent crimes. 2 malice crimes. So on the bar exam, there are only 2 malice crimes: murder and arson. Of course, I mean here, what I just talked about, murder being common law murder, what we usually refer to as second-degree murder in most jurisdictions. So what's this mean? It means we don't need specific intent for these crimes. What do we need? We're going to talk about this a little bit later on. You can write it down if you want. What do you need? A reckless disregard. That's the key phrase here. Reckless disregard. There's a high risk that the harmful act would occur. Murder, arson, malice crimes, don't need specific intent, just a reckless disregard, high risk that that harmful act would occur. 3, general intent. So general intent is kind of a big catch-all category. All crimes not so far mentioned are general intent crimes unless they qualify for strict liability. And the most common general intent crimes in the bar exam: rape and battery. Those are the most common general intent crimes that you'll see show up on the bar exam. Again, big catch-all. Anything not heretofore mentioned is a general intent crime unless qualifies for strict liability. Which jumps us to hypo number 5, talking about our mental states and intent. I want to kill the woman wearing the Barney the Dinosaur shirt. Hey kids. I pull out my gun, I fire at the woman in the Barney shirt. The shot misses her. Instead, hits and kills the woman in the Dora the Explorer shirt sitting behind her. Now guys, I did not mean to hit this woman. I happen to love Dora. She explores the world. She's bilingual. She has a friend who's a talking monkey. I love her, but nonetheless, this is who I shot. The question is, am I guilty of murder? Answer, yes. Answer, yes. Why? Because of the doctrine of transferred intent. Answer yes. Why? Because of the doctrine of transferred intent. So my intent to kill the woman in the Barney shirt is transferred to govern the death of the woman in the Dora the Explorer shirt. My intent transfers. And therefore, because I had specific intent in this actual case, it would be first-degree murder. Now, this type of vignette, the transferred intent hypothetical, is on the exam for the MBE approximately 2/3 of the time. Also great fodder for essays in most every jurisdiction. Hypo number 6. Under the fact pattern we just talked about in hypo number 5, can I be charged with 2 crimes? Answer, yes. And this is most often what they test you on here. There are always 2 crimes. Always 2 crimes in the transferred intent hypothetical. Always 2 crimes in the transferred intent hypothetical. We have the murder regard to the woman that I hit and killed. Of course, again, the intent transfers, first-degree murder here. That's easy enough, right? But we also have attempted murder regard to the woman I shot at and missed. Also have attempted murder regard to the woman I shot at and missed. Now, some of you had your coffee today, and you think, well, Professor Numeral, why don't these 2 crimes merge? We talked about merger earlier. Because there are 2 victims. There's no merger here because there are 2 victims. We never have merger when we have different victims. Again, watch out for the transfer intent and know you can be charged with 2 crimes. And for the last of our mental states, we alluded to earlier, strict liability, the no intent crimes. I want you guys to think strict liability, no intent, strict liability, no intent, strict liability, no intent. That's the phrase that pays. So the importance of strict liability in the bar exam is that any defense that negates a substantial, unjustifiable risk, and similarly, negligently, one acts negligently when he fails to be aware of a substantial, unjustifiable risk. Recklessly, we're consciously disregarding substantial and unjustifiable risk. Negligently, we're failing to be aware of substantial, unjustifiable risk. Those are our 4 mental states and the model penal code, which they do test you on, but we're not going to bring into play unless we're told this jurisdiction has adopted the model penal code. All right, guys, that jumps us to Roman numeral 3, accomplice liability. Here's your general rule. An accomplice is one who aids, advises, or encourages. Aids, advises, or encourages. Key phrase to remember here for our rule. Aids, advises, or encourages the principal in the commission of the crime charged. Aids, advises, encourages. Aid. Hey. You know, I don't want to be part of this robbery, but I know you need the money, so I'll lend you my car. Just give it back to me after you're done. Advise. Hey, you know what? I know you're going to knock over that bank. I used to work there. Let me tell you the kind of layout of the place. Let me tell you when the security guard takes his breaks and where he goes and how long he's gone. I don't need to have any part in the actual robbery, but, you know, I'll help you out a little bit. Or encourage. Hey. You got to kill Joey, man. You got to kill Joey. You got to do this, man. He's got a big mouth. He's going to take us all down. This is up to you, man. You got to do this. This is on you, okay? Here's your visual. Aid, a little bit of shoveling, maybe under the bank. Advise, whisper in the air, and encourage. Aid, advise, encourage. Visual, remember, aid, advise, encourage, won't forget it. B, accomplices must also have the requisite intent that the crime be committed. If I lend you my car to go to the grocery store, but you actually take my car and you go knock off a bank, no criminal liability because I didn't have the intent there. And C, accomplices are liable for the crime itself and all other foreseeable crimes. The crime itself and all other foreseeable crimes. Knock off a bank, you know you're going in with guns, it's foreseeable that a bank teller might get shot. Accomplices liable for the crime itself, all other foreseeable crimes. Hype number 9. Newman standing outside of a bank chatting on his cell phone. He sees a van screech to a halt. 5 masked men jump out and run past Newman to the bank. Newman ends his phone call, pulls out a bag of popcorn, and watches as one of the masked men shoots a gun in the air and yells, "This is a robbery! Everybody get down." Newman laughs as he watches the robbery take place and later waves to the men as they leave the bank and speed away in the van. Newman never called the police. Question: does Newman have any criminal liability here as an accomplice? Answer: no. Not enough here for aiding or encouraging. Not enough here for aiding or encouraging. It's got to be some sort of active participation in the crime. Some way. Some active participation. And remember, as an aside here, no Good Samaritan law is a common law. So common law has no duty for Newman here to call the police. D. As far as accomplices and withdrawal, if the person encouraged the crime, the person must repudiate the encouragement. Must repudiate the encouragement. Joey's not going to turn over on us. He's not a rat. You shouldn't kill him. I take it back. You shouldn't kill him. 2. If the person aided by providing assistance to the principal, such as giving materials, he must do everything possible to neutralize this assistance. Neutralize this assistance, such as attempting to retrieve the materials, such as retrieving the shovel that he gave to the principal so the principal could dig under the bank. And 3, an alternate means always of withdrawing is to contact the police. Alternate means of withdrawing to contact the police. Accomplice liability, aid, advise, encourage. Sometimes you'll see the word counsel instead of the word encourage. Either one is fine. Aid, advise, encourage. Roman numeral 4, as far as our inchoate offenses, inchoate means incomplete. And we alluded to this earlier, but there are 3 inchoate offenses, and here they are. A, solicitation. Here's your rule. Solicitation is asking someone to commit a crime. Solicitation, asking someone to commit a crime. The crime of solicitation ends when you ask them. Hey, let's go knock over the Quickie Mart. Asking someone to commit a crime. 2, note, under the common law, it's not necessary the person solicited agree to commit the crime. Not necessary in the common law, the person solicited agreed to commit the crime. So 3, what if the person you ask does in fact agree to do it? Then it becomes a conspiracy. If the person you ask to commit the crime agrees to do it, then it becomes a conspiracy. And the solicitation merges, remember this when we first started? And the only crime left, the other person agrees to do it, is conspiracy. Why? Because solicitation merges. 4, note, factual impossibility is no defense. Factual impossibility is no defense. B, conspiracy. Your rule for conspiracy. This is how I want you to think of conspiracy. Break apart our rules. It's always what we do in criminal law. We have different elements of a crime, right? So we break apart our rule. Conspiracy is an agreement with an intent to agree and an intent to pursue an unlawful objective. Agreement, intent to agree, an intent to pursue an unlawful objective, which jumps us to hype number 10. Kramer buys a new super spy set and wants to try it out. He and George agree to break into Kramer's house at midnight with their new tools, grab some silverware, and go pawn it. They dress in black clothes and black ski masks. They get a ladder, pop the latch on the second floor window with a tool from the super spy set. They enter the house. They then grab some of Kramer's silverware from the kitchen and they pawn it at an all-night pawn shop. Question: is this a conspiracy? Answer: no. Well, we have an agreement though, and we have an intent to agree. Why is the answer no? Because it's not unlawful for Kramer to break into his own house, pawn his own silverware. It's not unlawful for him to do this. And remember, these people must be pursuing an unlawful objective. Watch out for that on the MBE. They love to try and trip you up on that. Must be pursuing an unlawful objective. They're not doing so in hypo number 10. 2, here's some notes on the common law conspiracy, things to look out for the MBE. A, we talked about a little bit earlier, but again, an important concept. Conspiracy does not merge the substantive offense. So on the bar exam, you can, C-A-N, can, be convicted of conspiring to do something and then actually doing it. Base example here, robbery and conspiracy to commit robbery. You can be properly convicted of both. Why? Because there's no merger for conspiracy, unlike our other 2 encoded offenses, the solicitation and the attempt. Base example, robbery, conspiracy to commit robbery. No merger, can be convicted of both. B, as far as liability for co-conspirators' crimes, each conspirator is liable for all crimes of co-conspirators if those crimes were committed in furtherance of the conspiracy and were foreseeable. In furtherance of the conspiracy and were foreseeable. I like to say the 2 F's of co-conspirator liability. Furtherance of conspiracy and foreseeable. The 2 F's, co-conspirator liability, that shows up a lot on the exam are 2 F's. C, as far as the agreement requirement for conspiracies, the agreement need not be expressed. The agreement need not be expressed. Intent can be inferred from conduct. The agreement need not be expressed. How is this so? Well, intent can be inferred from conduct. We have 2 basic approaches we need to know here. One is the bilateral approach. So the traditional common law rule required 2 guilty parties. Thus, under this approach, if one person in a 2-party conspiracy is merely feigning agreement, the other person cannot be guilty of conspiracy. Bilateral approach requires 2 guilty parties. One person feigning, the other cannot be guilty of conspiracy. Furthermore, the acquittal of all persons with whom a defendant is alleged to have conspired precludes conviction of the remaining defendant under this approach, the bilateral approach. The unilateral approach. So the modern trend and the model penal code approach requires only that one person have a genuine criminal intent. Only that one person have a genuine criminal intent. The trend right now is for the unilateral approach. So what is the majority? What is the minority? We don't need to worry about that for this, because what they've done, if they do test you on the MBE, they will tell you this jurisdiction follows the model penal code approach or follows the bilateral approach, and they will be pretty specific on that. So we don't need to know, but we do need to know bilateral versus unilateral, and otherwise we should know that they will tell us which one we're supposed to apply. Double stars on D, the overt act requirement. So the majority rule is that in order to ground liability for conspiracy, there must be an agreement plus some overt act in furtherance of the conspiracy. The minority rule, common law rule, ground liability for conspiracy with the agreement itself. No overt act required, just the agreement itself. So one, if you're operating on the majority rule, it requires an agreement plus an overt act, any little act will do to be an overt act and furthers conspiracy, even an act of mere preparation. Even an act of mere preparation. And when we talk about any little act, literally any little act will do. Buying ski masks before robbing the bank. Even showing up at the Quickie Mart that you agreed to rob. That's enough to constitute any little act. And again, mere preparation is enough. 2. Student notes on the MBE regarding majority and minority rules. We've talked about a few of them now. Always apply the majority rule unless specifically told otherwise. Always apply the majority rule unless specifically told otherwise. And E, factual impossibility, no defense to conspiracy. Factual impossibility, no defense to conspiracy. F, withdrawal, even if it is adequate, can never relieve the defendant from liability for conspiracy itself. The defendant can withdraw from liability for the other conspirators' subsequent crimes, but he cannot withdraw from this conspiracy. Only the other conspirators' subsequent crimes subsequent to the withdrawal. So we have a good grip on conspiracy. Let's find out. Come with me, if you would, to hypo number 11. Hypo number 11. Derek and Hansel agreed to break into Matilda's house in order to get money for their school for kids who can't read good. They were arrested shortly after they pried open Matilda's back door near the house. Both were charged with conspiracy to commit larceny, among other crimes. Derek testified that he had long suspected Hansel of being a thief, and he agreed to the plan in order to catch Hansel. He made an anonymous telephone call to the police, alerting them to the crime, enabling the police to arrest them, quote, in the act, end quote. Derek also testified that he did not intend to keep the money. Hansel did not testify. The jurisdiction follows common law conspiracy rules. As to the charge of conspiracy to commit larceny, if the jury believes Derek, and they love to do this and prompt the question, assuming the jury does believe this person, if the jury believes Derek, it should find him A, not guilty because he did not intend to steal, B, not guilty because he prevented the theft from occurring, C, guilty because there's an agreement that prying open the back door was sufficient for the overt act, D, guilty because he's not a police officer and thus cannot claim any privilege of apprehending criminals. What is the best answer? Well, again, always think about what's our rule. What do we need for a conspiracy? We need an agreement. an intent to agree, an intent to pursue an unlawful objective. And in some jurisdictions, we need an overt act, but not in this particular hypo. Why? Because we're following common law conspiracy rules here, which does not require any overt act, only the agreement itself. Important to keep in mind. So having those things in mind, we go through A, not guilty because he had not intended to steal. In fact, there was no intent to steal here, and therefore cannot be guilty of conspiracy if in fact the jury believes, and therefore the correct answer is in fact A. B, not guilty because he prevented theft from occurring, is incorrect here because the intent is the key that makes B incorrect, not as good an answer as we have in A. C, guilty because an agreement, prying open the back door was sufficient for the overt act. True, there was an agreement, and the prying open the back door would have been a sufficient overt act if we're in a majority jurisdiction that requires that, but still, nonetheless, there is no intent. The jury believes that he was only doing this in order to catch Hansel, wasn't going to keep the money, therefore C cannot be the correct answer. And D, there's no apprehending here. Merely alluring the police is not apprehending, so that's not in play. Again, correct answer here is A. Alright guys, hang with me for just a couple more minutes through attempt and we'll take our first break. The last of our 3 inchoate crimes. I think we all know what we're talking about here. Attempt is when you want to commit a crime, but you're just not a very good criminal, so you fall short. You can still be charged with the crime of attempt. Here's our rule, C1. What do you need for attempt? Specific intent, remember it's a specific intent crime, plus 2, an overt act in furtherance of the crime. An overt act in furtherance of the crime. And 2, for purposes of attempt, the overt act must be a substantial step. In furtherance of commission of the crime, substantial step. Thus, mere preparation cannot ground liability for attempt, whereas it can for conspiracy. But mere preparation cannot ground liability for attempt. 3. As far as the defense of abandonment, which shows up from time to time on the MBE, the majority rule is that once defendant has taken a substantial step toward committing the crime, abandonment is never a defense. Abandonment is never a defense once we have the substantial step. But the model penal code allows for its defense only if it's a fully voluntary, only if it is fully voluntary and a complete renunciation of criminal purpose. Model penal code allows for its defense, but only if it is fully voluntary and a complete renunciation of criminal purpose. And 4, as far as impossibility is concerned, legal impossibility is a defense to attempt. Legal impossibility is a defense to attempt. Don't be confused by this. That just means whatever persons were trying to do was not actually illegal. So legal impossibility is a defense. But factual impossibility is not a defense. But factual impossibility, not a defense. In fact, factual impossibility, not a defense to any of our 3 inchoate offenses. Alright guys, hang with me through hypo number 12. Flesh this out a little bit more. Hypo number 12. Snooki and JWoww agreed to rob an armored car to pay off their tanning salon debt. Just make me more orange. I just want to be more orange. They purchased the necessary equipment and weapons, rush the armored car when it comes to stop in front of a bank. However, they're throwing the guards out of the armored car. They discover there's no money in the armored car. Question: can Snooki and JWoww be convicted of attempted armed robbery? Answer: yes, they can. Why? How can they be? There's no money. How can they be convicted of attempted armed robbery here? Because factual impossibility is not a defense. Why? Because factual impossibility is not a defense. It was factually impossible for them to actually get the money. But for our inchoate offenses, factual impossibility, never defense, here can in fact be convicted of the attempted armed robbery. All right, guys, that brings us to a good stopping point. We'll stop here. We'll take a 10-minute break. We'll come back and pick up hour number 2 in 10 minutes. Welcome back, everyone. Welcome back. Simmer down now. Listen, simmer down. So I know it's always hard to jump right back in the substantive portion of the lecture. So while we're all easing back into our chairs, I thought maybe start a little quick review. A couple things, hopefully, that we learned from hour 1. 2 things I want to focus on, 2 things that I think we really need to know. Number 1 is our mnemonic for specific intent crimes. Students can always fake a laugh, even for ridiculous bar facts. Students can always fake a laugh, even for ridiculous bar facts. Now, I give you this to try and help you remember the specific intent crimes, but also, it's true to life. It's something to take with you for the exam. So, literally, I mean, on the exam, there's usually some question or 2, essay question or whatnot, that's just out of left field. So when you get this, fake a laugh, right? When you get this question, you're like, I have no idea what it is. Just laugh. Fake a laugh. Because you know what? If you're going down, you might as well try and distract as many people around you and take them down with you, right? Question 5. Students can always fake a laugh, even for ridiculous bar facts. Right? Use it. It'll help. And number 2. Accomplice liability, right? So, true story, I get an email from a student. I do these things, these little things, to help memorialize some rules that you guys might, oh yeah, I remember what that is, right? So, a couple years ago, actually 2 years ago now, I get an email from a student. It says, Professor Norrell, you know, thanks for your lecture, you know, the accomplice liability. So, I'm doing this practice Barbary essay, and I can't remember the rule for accomplice liability, but I remembered shovel, whisper, fist pump. So I wrote that in for the rule. Accomplice liability is shovel, whisper, fist pump, blah, blah, blah. Thinking I would go back and then I'd write the real rule because I'd remember it. And then this person forgot to write in the actual rule, turned in the Barbary essay with the rule for accomplice liability being shovel, whisper, fist pump. And of course, you can imagine the Barbary grader, when I got back, I don't think this is the correct rule for accomplice liability. So look, try and help remember, but accomplice liability is not shovel, whisper, fist pump. What is it? Aid, give him the shovel so they can dig under. Advise, whisper, encourage. Kill Joey, we need to kill Joey. Accomplice liability, often tested. As is, what we have to know, our mnemonic, specific intent crime. Students can always fake a laugh, even for ridiculous bar facts. Remember, remember, remember. Gotta know rules. All right, guys. That's enough for our quick review. Let's jump back in. Roman numeral 5, our defenses for crimes based on criminal capacity. First, we have insanity. What many of us are experiencing right now, I am sure. Here's what we need to know for the bar exam. The 4 trigger phrases. They're tied to the 4 tests for the insanity defense. The 4 tests for insanity are: 1, the McNaughton test. So the McNaughton rule says this. At the time of his conduct, defendant lacked the ability to know the wrongfulness of his actions. Defendant lacked the ability to know the wrongfulness of his actions, or understand the nature and quality of his actions. 2, irresistible impulse. Defendant lacked the capacity for self-control and free choice. Irresistible impulse. Defendant lacked capacity for self-control and free choice. 3, the Durham Rule. Only one we're not lacking in something. Defendant's conduct was a product of mental illness. A product of mental illness. Conduct was a product of mental illness, Durham. And 4, the Model Penal Code version, defendant lacked the ability to conform his conduct to the requirements of law. The ability to conform his conduct, pardon me, to the requirements of law. Generally speaking, they'll tell you that the jurisdiction adopted this rule, right? The Durham Rule, irresistible impulse, whatever it might be. Know the name and know the trigger phases. 3 of the 4 are lacking in something, and the one that's not, Durham Rule, product of mental illness. B, intoxication. First we have voluntary intoxication, which we all know, self-induced intoxication. A. So voluntary intoxication is a defense on the bar exam only to specific intent crimes. No other kind of crime. Specific intent crimes. One of our 2 additional defenses available for specific intent crimes, and specific intent crimes only. Which jumps us to hypo number 13. This is the kind of thing that's always on the bar exam when they test you on specific intent crimes. After drinking heavily, Barney breaks into Homer's house at night to steal Homer's TV.
Kind of pathetic, Joe. You take me for a Homer. Hey, there's beer in that ashtray.
Sorry. Whoop, whoop, whoop. Homer, whatever it takes. Homer sees this and rushes toward Barney. Barney then punches Homer, knocking him out. Barney takes Homer's TV, gets in his car, speeds away, is pulled over for speeding a few blocks away. Question. With what crimes can Barney be properly charged and convicted? A, battery. B, burglary. C, both battery and burglary. D, neither battery nor burglary. Well, let's break this down. Anytime you see someone drinking heavily, we know it's voluntary intoxication. And we know what? Voluntary intoxication is defense to specific intent crimes only. Do we have any specific intent crimes in play here? Yep. Burglary. Remember our mnemonic. Burglary, a specific intent crime, but battery is a general intent crime, so no defense there. Correct answer, therefore, is A, battery and battery only. Why? For the burglary, there's a defense, the voluntary intoxication. B, note. For purposes of the bar exam, addicts and alcoholics are always voluntarily intoxicated. Addicts and alcoholics, always voluntarily intoxicated. What I mean by this is that they cannot, by virtue of their status as an addict or an alcoholic, claim involuntary intoxication. Cannot claim involuntary intoxication just by virtue of their status as an addict or an alcoholic. They're always considered, purpose of the bar exam, voluntarily intoxicated. And 2, speaking of involuntary intoxication, what is involuntary intoxication? Here's our rule. 1, it's unknowingly being intoxicated, or 2, being intoxicated under duress. Under duress. Examples: A, you have something slipped in your drink. You didn't know what it was or what its effects are. Or B, you are forced, under duress, you are forced to drink. Involuntary intoxication. And C, note, involuntary intoxication is a form of insanity. Thus is a defense to all crimes. It's a form of, considered to be a form of insanity, and thus defense to all crimes, involuntary intoxication. C, next, list of our defenses, criminal capacity, infancy. So remember these 2 rules, you can't go wrong with any type of infancy question. 1, underage 7, no criminal liability. Easy enough. 2, underage 14, rebuttable presumption. A rebuttable presumption of no criminal liability. Age 7, no criminal liability. Underage 14, rebuttable presumption, no criminal liability. All right, guys, that jumps us to Roman numeral 6, principles of exculpation of the defenses. First we have self-defense, A1. Well, let's talk about non-deadly force first. Here's our rule, self-defense using non-deadly force. A victim may use non-deadly self-defense anytime the victim, key phrase here, reasonably believes that force is about to be used on him. Anytime the victim reasonably believes that force is about to be used on him. 2, as far as use of deadly force in self-defense. A, majority rule. A victim may use deadly force In self-defense, anytime the victim reasonably believes that deadly force is about to be used on him. Anytime the victim reasonably believes that deadly force is about to be used on him. B, the minority rule, just because it's fun to have majority-minority rules so we can remember more things. The minority rule is a victim is required to retreat if it is safe to do so. A victim is required to retreat if it is safe to do so. If, but only if, examiners tell you you're in one of these so-called retreat or minority jurisdictions, and there are 3 exceptions to that duty to retreat, and here they are. 1, there's no duty to retreat from your home. And 2, there's no duty to retreat if you're the victim of a rape or a robbery. No duty to retreat from your home, or if you're a victim of a rape or a robbery. And 3, police officers have no duty to retreat. Again, always apply the majority rule unless specifically told otherwise. And by the way, guys, they do in fact test you on the minority rules, so we need to know them. But we don't apply the minority rules unless we're specifically told to do so. Let's flesh this out a little bit more with hypo number 14. Defendant, a worker at a metalworking shop, lawman teasing Vincent, a young colleague, by calling him insulting names and ridiculing him. One day, Vincent responded to the teasing by picking up a metal bar, attacking defendant. Defendant could have escaped from the shop. Defendant could have escaped from the shop. But instead, he picked up his own metal bar and struck Vincent in the head. Vincent later died from this blow to the head. Question, what's the most serious offense which defendant can be properly convicted? A, involuntary manslaughter. B, voluntary manslaughter. C, murder. Or D, none of the above. What is the best answer? Again, always think about what is the rule in play here. Well, what's the issue in play is self-defense, right? So what's our rule? Well, the majority rule, which we're going to apply here, is that a victim may use deadly force anytime the victim reasonably believes that deadly force is about to be used on him. Is there a reasonable belief here that deadly force is about to be used on the defendant? Yeah, I would say so. A metal bar, you're going to be attacked with a metal bar. That's a reasonable belief that deadly force is about to be used on you. Therefore, what can you do? You can respond with deadly force and have a valid defense of self-defense. Therefore, correct answer, none of the above. Valid self-defense in play here. Correct answer here is D. Guys, let me make this little side point. There's a little space down there if you want to write this in. Look, do not be confused by the language. You see here where it says defendant could have escaped from the shop, right? They love to do that in the MBE. They love to throw in language that makes you think about the minority rule, but then they don't tell you that you're in a minority rule jurisdiction. So watch out for that. Doesn't matter if he could have escaped from the shop unless they tell you you're in a minority or retreat jurisdiction, which they did not. Therefore, we apply the majority rule. Again, correct answer here is D. Watch out for those little things on the bar exam. 3. As far as the original aggressor in self-defense, A, to get back the defense of self-defense, the original aggressor must 1, withdraw, and 2, communicate that withdrawal. To get back the defense of self-defense, the original aggressor, withdraw, communicate that withdrawal. So quite literally on the exam, the original aggressor must stop and then literally say, hey, I'm done beating you to a pulp now and I'm leaving, right? And I'm not trying to be funny about that. Quite literally, something such as that must appear in the exam for the original aggressor to get back the defense of self-defense. Otherwise, doesn't get it back. B, note. If the victim of the initial aggression suddenly escalates a minor fight, escalates a minor fight to one involving deadly force and does so without giving the aggressor the opportunity to withdraw, the original aggressor may use force in his own defense, including deadly force, if in fact that's reasonable. 4, as far as the defense of others is concerned, A, our rule, Defendant can raise a defense of others defense if he reasonably believes the person assisted would have had the right to use force in his own defense. To use force in his own defense. Coming to the aid of someone else. Defense of others. If he reasonably believes the person assisted would have the right to use force in his own defense. And B, the majority rule here, there need not be a special relationship between defendant and the person whose defense he acted. Majority rule need not be a special relationship. Could anybody walking down the street that you see, right, getting pulverized in an alley? It used to be the special relationship had to be some kind of family member. The majority rule now is there need not be that special relationship. B, defense of a dwelling. There's only one rule, it's pretty easy, and there's only one type of question, and it's pretty easy too. Here's our rule. Deadly force may never be used solely to defend your property. Deadly force never used to solely defend your property. It's our rule, which jumps us to hypo number 15. Dwight's going on vacation. He's worried about someone breaking into his house. Accordingly, he loads up a spring gun in his front door. So if someone tries to open the door, the gun will be triggered, shoot the intruder. In dire need of a beat fix, Michael breaks into Dwight's house. The gun goes off and kills Michael. Question. Does Dwight have a viable defense based on defense of his dwelling? Answer. No. Cannot use deadly force solely to defend your property. Answer. No. Why? Cannot use deadly force solely to defend your property. This is the notorious spring gun question. Fact. Spring gun question on the exam 25% of the time. Fact. Bears eat beets. Bears beets Battlestar Galactica. Okay. Guys, no. So I get this question a lot of times, so let me head it off. So people ask, well, you know, that hypo number 15, so Professor Mel, you're saying that, you know, if I'm home sleeping, my family's there, and someone breaks in the house, I can't use deadly force. That's a different scenario. Completely different scenario there because you're home. So if deadly force is used and it's reasonable, then you are, in fact, protecting not only your property, but also yourself and your family. Different than hypo number 15, where Dwight is not there. The spring gun question necessarily dictates they're only defending the property because they're away on vacation. Watch out for that little distinction. And watch out for the spring gun question again, 25% of the time on the MBE, some way, shape, or form. C. Duress. Here's our rule. Duress is defense to a criminal act if A, the person acts under threat of imminent infliction, death, or great bodily harm. Person acts, commit this crime, threat of infliction, death, or great bodily harm, and B, that belief is reasonable. That belief must be reasonable. 2. Threats to harm a third person may also suffice to establish the defense of duress. Threats to harm a third person. We're going to kill your wife unless you rob this bank for us. And 3, note, duress is defense to all crimes except homicide. It's defense to all crimes except homicide. We're going to kill you unless you kill Joe. Right? No defense there. Why duress? Not defense to homicide. D, necessity. Our rule. So conduct that would otherwise be criminal is justifiable if the result of pressure from, key phrase here, we're talking about necessity, natural forces. Result of pressure from natural forces. The defendant reasonably believes this conduct was necessary to avoid a greater societal harm. conduct necessary to avoid a greater societal harm. So just in case we're wondering, what are these natural forces we're talking about? Floods, tornadoes, hurricane, lightning, start to fire. Natural forces. 2. Note, the necessity defense differs from duress because duress involves a human threat. Necessity involves pressure from the natural forces. Human threat versus natural forces. Alright guys, that jumps us to E, mistake of fact, double stars here. They love this one of the all-time MBE favorites. Almost assuredly going to be on the exam. Mistake of fact, let's jump into it. 1, our rule. Mistake of fact is a defense only when the mistake negates intention. Mistake of fact, defense only when the mistake negates intention. 2, the mistake has to be reasonable to be a defense to a malice or general intent crime. It's got to be a reasonable mistake. Reasonable. 3, but on the bar exam, any mistake, no matter how ridiculous, is a defense if the defendant's charged with a what? Specific intent crime. Specific intent crime. The second of our 2 additional defenses available only for specific intent crimes, known as unreasonable mistake of fact. And 4, mistake of fact is never a defense to strict liability crimes. Never a defense to strict liability crimes. Pardon me. And here, guys, we could revisit Duke and Linda, hypos number 7 and 8. Duke was mistaken as to her age. Does it matter? No. Why? Because that was a strict liability crime, so it's never going to be a defense. Mistake of fact, it was a strict liability crime. Alright guys, I think it's a good place for a quick review. I'm at the point now in your outline where it says, quick review. Also, this will be the interactive portion of the lecture, so we got that going for us. Quick review. The availability of mistake of fact defense. When can the defendant use this, right? When can the defendant use this? Specific intent crimes equals, and you can just make, 2 parallel lines if you want to instead of writing out the word equals. A little shorthand for you, just trying to help. Specific intent crimes equals any mistake at all. Specific intent, any mistake at all. Malice or general intent crimes, reasonable mistakes only. Reasonable mistakes only. And strict liability crimes, never a defense. Never a defense. The strict liability is never a defense. I was mistaken as to her age. Doesn't matter. It's a strict liability crime. Never a defense. Oh, question? Question? Oh, yeah, question. Professor Numeral, on the exam, how will I know if a mistake is reasonable or unreasonable? Answer. Thank you for this fantastic question, student who is about to pass the bar exam. So on the exam, they will do one of 2 things in this regard. 1, they will make it obvious. 1, they will make it obvious. Or 2, they will tell you if a mistake is reasonable or unreasonable. They'll make it obvious or they'll tell you. Couple very quick examples. I drive to this lecture today, my black Nissan Altima, and I leave and I get in a green and pink striped Volkswagen Bug. Now that is clearly an unreasonable mistake, and therefore I only have a defense. What? If it's a specific intent crime. That's obvious that mistake is just not reasonable, right? Or they'll just tell you by saying, Professor Numeral unreasonably mistaking John's car for his own, or whatever it might be, or they'll say reasonably mistaking X for Y. So they'll do a pretty good job, either making it obvious or actually telling you. Oh, I see there's another question. Question. What is the difference between mistake of fact and factual impossibility? Another great question. Question I always get. So thought we'd lay it out here. When dealing with mistake of fact as a defense, the defendant never has the intent. If it's a valid defense here, defendant never has the intent. When dealing with factual impossibility, the defendant has the intent to commit the crime. But it's just impossible to do so because of the factual circumstances. Dealing with factual impossibility, the defendant has the intent to commit the crime, but it's impossible to do so because of the factual circumstance. Don't confuse those two concepts. And here we could revisit our crazy kids, Snooki and JWoww, and who wouldn't want to revisit those crazy kids, right? And we'd see that, well, it was factually impossible for them to commit the crime, but they had the intent to do so. That's dealing with factual impossibility. As opposed to mistake of fact, when that's a valid defense, the defendant never has the intent to commit the crime. They just reasonably or unreasonably mistook this for that. All right, guys, that jumps us to F, consent. There's only one thing you really need to know here. Consent to the victim is generally no defense. Anytime they bring in consent and answer choice, be very leery of it, unless we're talking about one specific concept, which we'll talk a little bit later on, but generally, consent, no defense. G, entrapment. What's our rule? Entrapment is a valid defense only if 1. The criminal design originated with law enforcement officers. Valid defense only if the criminal design originated with law enforcement officers. And 2, the defendant must not have been predisposed to commit the crime. The defendant must not have been predisposed to commit the crime. Watch out, guys, on the exam for undercover police officers buying or selling drugs. If there's an undercover police officer, maybe someone posing online in a chat room as an underage child, watch out for those scenarios. They come up a lot. If, in fact, there's any undercover officer, they always want you to discuss entrapment as an issue. But most always, we're going to what? Give the rule, apply the facts, and then say entrapment's not a valid defense because it's a very, very difficult threshold for that rule for defendants to meet. All right, guys. Follow me, if you would, to our offenses against the person. What we're talking about here are common law crimes. I think, before we jump into it, I think everyone knows this, but just in case we don't, no state now has just common law crimes. All crimes have been codified by statute. So what are the common law crimes we don't remember from law school? Essentially, they are the crimes that existed in England in the 1700s. And you all get to learn those. Why? Because the bar examiners are sadists and they don't like you very much. No. Actually, well, it may or may not be true, but they need some uniformity of answers. And because every state has a little bit different codification of crimes, at least the common law is all the same. So we get to learn common law. So off we go. A, batteries first. What's our rule for battery? Battery is the unlawful application of force to the person resulting in either bodily injury or offensive touching. Bodily injury or offensive touching. Bodily injury, offensive touching. 2, a battery need not be intentional. It's enough defendant caused application of force with criminal negligence. That's enough for battery. Defendant caused application of force with criminal negligence. And 3, the force need not be applied directly. The force need not be applied directly. And just so we know, something to look out for, someone poisoning someone else, right? Put a little poison in the food, person ingests that food, that can be a battery even though the force was not applied directly. And 4, remember that battery is a general intent crime. General intent crime. Of course, the significance of this, those 2 additional defenses not available for charges of battery. B, assault. What's an assault? Well, there's a couple different definitions of assault. One is an attempt to commit a battery. An attempt to commit a battery. I swing at someone trying to hit them, but I miss them. It could be an assault. Or 2, the intentional creation, other than by mere words, of a reasonable apprehension of imminent bodily harm. Key phrase here, other than by mere words, a reasonable apprehension of imminent bodily harm. And 3, as far as the assault battery distinction, down and dirty way of remembering this, if there's been an actual touching, the crime is battery. Period. If there's been actual touching, the crime is battery. And C, as far as aggravated assault is concerned, aggravated assault is assault plus one of the following. 1, the use of a deadly or dangerous weapon. The use of a deadly or dangerous weapon doesn't have to be just a gun or a knife. It could be something that's considered a dangerous weapon. Or 2, the intent to rape, maim, or murder. Or assault, the intent to rape, maim, or murder, brings it up to aggravated assault. Alright guys, that jumps us to D, homicide. Sure to be on the exam. Bar examiners, for whatever reason, they love dead bodies, so they will be on the exam. Again, just as a quick reminder, guys, if we see the word murder on the MBE and there's nothing else around murder, just says murder, what do they mean? Common law murder, which we call second-degree murder, right? Significance of this, again, is that it's not a specific intent crime, and therefore those 2 additional defenses not available. Why do I keep coming back to this? Because it's almost always on the bar exam. And I care. So let's talk about this. Homicides are big umbrella, and then we're going to kind of break it down. Murder, degrees of murder, manslaughter. So here we go. Murder, generally speaking, our rule, murder is the unlawful killing of another human being with malice aforethought. So when does someone have malice aforethought? Well, such a state of mind exists if there's A, intent to kill, or B, intent to inflict great bodily harm. Intent to kill, intent to inflict great bodily harm. Or C, intent to commit a felony. Intent to kill, intent to inflict great bodily harm, intent to commit a felony. These are iterations of first-degree murder. Or D, reckless indifference, an unjustifiably high risk to human life, commonly known as second-degree murder. Reckless indifference, an unjustifiably high risk to human life. State of mind for malice aforethought. First 3, first-degree murder, and D, known commonly as our second-degree murder. A couple other things we need, though, too. Number 2, we need cause in fact. So what is this? Well, defendant's conduct must be the cause in fact of the victim's death. In other words, the death would not have occurred but for defendant's conduct. But for defendant's conduct. And 3, we also need proximate cause, right? So the general rule, the defendant is responsible for all results that occur as a natural and probable consequence. Natural and probable consequence of his conduct, even if he did not anticipate the exact manner in which they would occur. Alright, so under our big umbrella of homicide, now we're going to talk about our murder and degrees of murder. First, we're going to start with first-degree murder. There are 3 kinds of first-degree murder. Number 1, a premeditated killing. A premeditated killing. 1. First, the victim must be human. Yes, the victim must be human. And why do I say this? Because many years ago, on the exam, you see there was this dolphin, right? I don't know if this dolphin could solve crimes or write novels or whatever the dolphin could do, but in the fact pattern, quite literally, someone came up and said, hey, I hate your dolphin, I'm going to shoot it, shot the dolphin, kill the dolphin. Do you know that there were so many, apparently, brain-dead examinees that a very, very high percentage, in the teens, said that this constituted first-degree murder, right? So 4 years later, after this question, because so many people responded that first-degree murder to kill the dolphin, same fact pattern, except now it's a seeing eye dog. Comes up, I don't like your dog, shoots the dog. Is this first-degree murder? Not sure on that exam how many people actually said it was, but you know not to fall in that trap. Animals are there to confuse you, to toy with your emotions, right? Victim must be human. And also, don't forget, victim must be human, but also the victim must actually be dead, right? So the thing to look out for here, they do sometimes, someone gets shot in the head and they go into a coma, right? Can't be any murder charge there because why? The victim is in fact not dead. So, quick review before we jump into this wholeheartedly. What we need, first degree murder, well, victim must be human and victim must be dead. See how easy this whole bar exam stuff is? Yeah? You go home tonight and like, oh honey, what did you learn for your bar review class today? Oh, I learned for murder, victim must be human and dead. Wow. How much we paid again for that bar review course? Yeah, right? Okay, we're learning human and dead. Onward and upward. Number 2, our premeditated killing, our rule. Defendant must have acted with intent or knowledge that his conduct would cause death. Defendant must have acted with intent or knowledge that his conduct would cause death. And B, felony murder. The second of our classification of first-degree murder. What is felony murder? What is our rule? Any killing, even an accidental killing, committed in the course of felony. That, common law, constitutes first-degree murder. Any killing, even an accidental one. But what they love to test you on, 2 double stars on 2, defenses to felony murder. A, if the defendant has a defense to the underlying felony, then he has a defense to felony murder. Love to test you on defenses to felony murder. If the defendant has a defense, the underlying felony is defense to felony murder, which jumps us to hype at number 16. Angelina and Brad hold up a convenience store. I know they make like $20 million a movie, but they've got like 38 kids now, right? So they probably need the money. Angelina is drunk. During the holdup, Brad accidentally shoots and kills the convenience store owner. Question: is Angelina guilty of felony murder? Answer: no. No. Why? Because she has a defense to the underlying felony. Answer: no. Why? Because she has a defense to the underlying felony. What's the underlying felony here? The robbery. What type of crime is robbery? A specific intent crime. What is a defense to specific intent crimes? Voluntary intoxication. Therefore, Angelina has a defense to the underlying felony, therefore a defense to felony murder. This type of question on the exam all the time. That's what we have to know, our specific intent crimes and those two additional defenses. And don't be distracted here, guys. So they try and draw your attention here. Oh, accidentally shoots. You think, oh, well, even an accident, still going to be felony murder because that's the rule. We have to peel back the layers to see that there is, in fact, a defense to the underlying felony, which gets a defense to felony murder. Watch out for an exam. Always, always on there in some way, shape, or form. B, the felony they are committing must be a felony other than the killing. Other than the killing. The killing itself cannot constitute the felony for purposes of elevating to felony murder and therefore automatic first degree. C, the deaths must be foreseeable. Must be foreseeable. And guys, just so we know, if a gun's being used, and most commonly they test here on like a robbery issue, if a gun's being used in the commission and someone gets shot and killed, it's almost always going to be foreseeable. The one thing to look out for here, where it's not foreseeable, some bystander having a heart attack. That's the one area they do test on. Someone has a heart attack, it's a bystander, and that's probably not going to get us to the foreseeability that we need for purposes of the felony murder. D, deaths caused while fleeing from a felony or felony murders. Right? That's easy enough, right? Deaths, driving away, hit someone, felony murder. But, big but, once the defendant reaches a point of temporary safety, deaths caused thereafter are not felony murders. Watch out for this one too because they like that, right? E, on the MBE, defendant is not liable for the death of a co-felon, the result of resistance by the victim or the police. Not liable. Death of a co-felon. Not true in all jurisdictions, but for purposes of the MBE, that's our rule we're going with. Which jumps us to hypo number 17. Simon and Pollock went to rob a convenience store with guns drawn. The store owner shoots at Simon, hits and kills bystander. Would Simon and Pollock be guilty of felony murder? Answer is easy here for our rule. The answer is yes. But take a look at hypo number 18. In desperate need of more money for plastic surgery, Heidi and Spencer hold up a convenience store with guns drawn. Store owner pulls out a gun and shoots and kills Spencer. Question is, Heidi guilty of felony murder? Answer, nope. Not in the MBE. Defendant not liable for the death of a co-felon. The result of this resistance by the victim or the police. Defendant not liable for the death of a co-felon. As a result, resistance by the victim, the store owner, or the police. And guys, that jumps us to our third category for first-degree murder. We have our premeditated killings, we have our felony murders, and now C, homicide of a police officer, automatically qualifying for first-degree murder if we meet our rule, and here's our rule. C1. The defendant must know the victim is a law enforcement officer. And 2, the victim must be acting in the line of duty. Victim must be acting in the line of duty. And those are our three categories will qualify as first-degree murder. But of course, we also have second-degree murder, which we've talked about a little bit, 2A. In many states, second-degree murder classified as a depraved heart killing. I want to introduce you to that term in case you see it. The depraved heart killing, which again, very similar to our common law murder. Killing done with reckless indifference, key phrase, unjustifiably high risk to human life. Or B, murders that are not classified as first-degree murders, not classified as premeditated killings, first-degree felony murders. In many states, if that's not one of those two things, then it automatically jumps down into the catch-all for second-degree murder. All right, under our big umbrella of homicide, we have our first-degree murder, our three categories, second-degree murder, and we have manslaughter. long and winding rule for voluntary manslaughter. Let's see what we got. A1. Voluntary manslaughter is killing in the heat of passion resulting from an adequate provocation by the victim. Killing in the heat of passion resulting from an adequate provocation by the victim. 2. The provocation must be one that would arouse sudden and intense passion in the mind of an ordinary person, such to cause him lose self-control. In the mind of an ordinary person. 3. There must not have been a sufficient time. There must not have been a sufficient time between the provocation and the killing for the passions of a reasonable person to cool. And 4. The defendant, in fact, did not cool off between the provocation and the killing. Which jumps us to hypo number 19. Jake takes his girlfriend Vienna out to dinner. At dinner, another patron, Emily, comes over and says hello to Jake. She recognizes from a previous date. In a fit of passionate rage and jealousy, Vienna takes out a gun, kills Emily. Question. Should Vienna be convicted with the lesser charge of voluntary manslaughter? Answer, no. Why not? Why isn't this qualifying for voluntary manslaughter? Because the response was not the type of passion be aroused in the mind of an ordinary person. Answer again, no. Why not? Why is it voluntary manslaughter? Because the response was not the type of passion be aroused in the mind of an ordinary person. Unless, of course, maybe you're actually on The Bachelor or The Bachelorette, because, you know, if you go out on a date with a guy and 5 other girls one time, then you love him so much that maybe you would take out a gun and kill someone, right? Yeah, I know. Not actually that funny, but whenever I'm in LA, for some reason that's really funny. I think I figured out because when I'm in LA, I think everyone in the audience has either been on The Bachelor or Bachelorette or knows someone who's been on there, so a little bit more funny, yeah. Note to self, kill the Bachelorette joke, except in LA. Yeah, we're back. Hey guys, as another aside here, be careful with them, again, putting phrases in that make you think about a particular rule being in play. And it is in play, but you see where they say, fit of passionate rage and jealousy, right? Don't let that phrase trip you up. Automatically you're thinking, oh, well, this is manslaughter. And manslaughter is at issue here, but we haven't met all prongs of the rule. And therefore, just because someone kills in the heat of passion, we got to go through all the iterations of the rule. Otherwise, it's not going to qualify for manslaughter unless we meet it all. So watch out for that. B, I want to talk about the imperfect self-defense. Imperfect self-defense, what is that? 1, so here's our rule. If defendant has an honest but unreasonable, an honest but unreasonable belief that his life was in imminent danger, and this defense will reduce a murder to a manslaughter, right? You come up on break to ask a question, you got a really sharp pencil in your hand. I honestly, truly believe that you're going to kill me with this pencil. And therefore, I kill you. I say, oh, it was self-defense. I honestly believe that. Well, that was unreasonable for me to believe that. But it might reduce the charge from murder to manslaughter in states that recognize the defense. However, as we see in 2, note, there are only some states that in fact recognize this doctrine. If they test you on, and they do, on the MBE, then they will say something to the effect this state recognizes the doctrine of imperfect self-defense. C. As far as involuntary manslaughter is concerned, what's our rule? What is it? 1, to killing of criminal negligence. Involuntary manslaughter, a killing of criminal negligence. Maybe you're driving, maybe you haven't slept in 36 hours, there's no way you should be driving. Maybe you're texting while you're driving and you go across the center line, hit and kill someone. That can be a crime of criminal negligence. Someone dies in that crime. That could get you to involuntary manslaughter. 1, killing of criminal negligence, or 2, misdemeanor manslaughter. Killing someone while committing a misdemeanor, or an unenumerated felony. Killing someone committing a misdemeanor or committing an unenumerated felony. So what's an unenumerated felony? Just so we know, so we're all on the same pages. Most states have a felony murder statute that says if you commit A, B, C, D, E, F felonies, then someone is killed during the course of one of these felonies, the enumerated felonies, so to speak, then that gets you to what? First-degree felony murder. But what about the felonies that are not on that list? Well, those are called unenumerated felonies. And if you kill someone in the commission of one of those unenumerated felonies, it gets you down to an involuntary manslaughter charge as opposed to the first-degree felony murder charge. All right, guys, that brings us to a good stopping point. We'll come back in 10 minutes exactly, pick up with our third and final hour, 10 minutes. See you then. Welcome back, everyone. Welcome back to hour number 3. Sadly, our final hour together. Again, before we jump right back into the substantive part of the outline, I just want to say a couple things, like maybe head off some questions. I get a lot of email questions. So, recently received an email, true story, and the subject line from a student email said, "Mistakes in your lecture outline." And I was like, oh, geez, it's terrible. Like, there's mistakes in my outline. What's going on here? So I said, Professor Numeral, thank you for your lectures, but I need to point out that there are 2 pretty glaring mistakes that you should fix in your outline. Number 1 is you misspelled JWOW in your hypo number 12. JWOW is with 2 W's, and I did not know that, so thank you for that point. And the other is apparently in hypo with Jake in Vienna, the person who got shot should be Tenley and not Emily, because Tenley was one of the final 2 people who made it there. So I am aware of this. I am aware and need to make the changes, and we'll do so. So please don't email me about those mistakes in the lecture handout. And more recently, I received an email on hypo number 19 with Jake in Vienna. It says, you really need to change Jake in Vienna. That was like 5 or 6 seasons ago, or however long it was ago. So make sure that you update that. I'd be glad to if someone just emailed me and tell me who these new people are, because I get all this information from my sister. So, no more mistakes. All right, guys, we left off in our outline. We just got finished talking about our homicide, common law crimes, ended up involuntary manslaughter, and that jumps us now to E, false imprisonment. Here's our rule for false imprisonment. What is it? It is the unlawful confinement of a person without his valid consent. Unlawful confinement of a person without his valid consent. 2 notes. If a known alternate route is available, a known alternate route is available, the confinement element will not be met for purposes of false imprisonment. If the person knew that they could just walk over and go out the back door, there's an alternate route, and that confinement element not going to be met for purposes of false imprisonment. 3, note, one's consent to the confinement precludes it from constituting false imprisonment. One's consent to the confinement precludes it from constituting false imprisonment. And again, as I alluded to earlier, consent to the victim, generally no defense. This is the one exception to that when we're dealing with false imprisonment. Next on our list, kidnapping. Our rule for kidnapping. Nothing. So, guys, I want to use this to illustrate a point. On the bar exam, blank happens. Blank happens. There's going to be some time where there's a rule that you knew down cold, and because of the adrenaline or because of the people next to you who are distracting you, you know the ones, the hummers, the tappers, you're just going to blank on a rule. So when that happens, when you do blank on a rule that you used to know, we have 2 options I'd like to talk about. Option number 1, I like to call the Homer Simpson approach. That is where you find the nearest closet, you take as many donuts as you can, and you hide in the closet and just hope and pray that everything works out for the best. Or what I really recommend is option number 2, use common sense. So many times we forget. We check our common sense at the door, right? We can't remember exactly what it is. What's commonsensically the rule? So let's try and figure it out, right? Because this is going to happen. We want to know the rule as precisely as we can, but if not, we have to try and craft a rule because there can be no analysis with application of fact to rule. We have to craft our rule. So, what do we think kidnapping entails? What's our rule for kidnapping? Well, commonsensically, kidnapping probably entails a kid and some sort of napping, right? Yeah, that's probably what it entails, right? And then I think, okay, well, does kidnapping have to be a kid? No, you can kidnap an adult, right? So what word are we going to use now? We're crafting our rule. Not a kid, but a person, right? Okay, so now we're dealing with a person. And what do we mean by napping? Do we mean a person who takes a little siesta? No. We don't mean that. By napping, we mean taking them, right? Taking them away from where they are, right? So now we're crafting our rule. We got a person, and we're taking that person away. And then we think about commonsensically, what is this? What does this rule mean? Well, if Silence of the Lambs has taught me anything, is that when you take someone away, this person, you put them in a deep, dark basement where no one else knows where they are, right? You confine them in this place that's a secret because no one else knows where they are. Quid pro quo, Clarice. Quid pro quo. Thank you, Silence of the Lambs. Everything I learned about the law, Silence of the Lambs. So, what do we have for our rule? Taking a person, confining them in this basement. Maybe we don't say the word basement. Confining in this area where no one knows about. Another word for that? Secret. So we have just crafted our rule. And if that was what we had, that's probably enough to get us by for a pretty good analysis. But for those of you keeping score at home, here is the specifics of our kidnapping rule. Rule. Kidnapping is confinement of a person. Confinement, pardon me, of a person with either 1, some movement, the napping, some movement. And by the way, just so you know, you might want to put this in a parenthetical in case you see it. The legal moniker here is asportation. Asportation. You might see that, just so you know. But all we need to know is 1, some movement, or 2, concealment in a secret place. Concealment in a secret place. Don't forget your common sense. Again, our rule, kidnapping is what? Confinement. A person with either some movement also legally known, the moniker is asportation, or to concealment in a secret place. That's our rule for kidnapping. All right, guys, come with me if you would to Roman numeral 8, our sex offenses. Just a couple things here that might show up on the exam. A, rape. 1. Really, there's only one thing you know about rape for purposes of the MBE on the bar exam. That is this: the slightest penetration completes the crime of rape. It's really the only thing I've asked about rape. As far as the MBE is concerned, the slightest penetration completes the crime of rape. B, as far as statutory rape is concerned, statutory rape is a strict liability crime, meaning consent of the victim, no defense, and mistake of fact is no defense. Consent of the victim, no defense. Mistake of fact, no defense. Never, ever, ever for statutory rape. And C, that brings us to crimes against nature and other sex crimes. Here we're talking about adultery, fornication, incest, bestiality, seduction, carnal knowledge. All of these things are disgusting, and thankfully not hardly ever, ever, ever on the bar exam, so fortunately, I don't have to talk about them. Instead, let's talk about the much more scintillating topic of Roman numeral 9, property crimes. There are 3 common law property crimes: larceny, embezzlement, false pretenses. Need to know the rules for each, the little nuances to the rules they test you. And they also, his neighbor's dog and sells it. Mistake of law is no excuse. And therefore the person can be guilty of common law larceny. Therefore the correct answer is in fact C. Mistake of law, I didn't know it was against the law to take this person's dog and sell it. But do you see, guys, do you see how they try and trip you up with these animals, right? I mean, seriously. If it is said here, mistakenly believing larceny does not include taking of a wallet, well then this is an easy one, right? Well, obviously. But the animals, you get all emotional, like, oh, but he sold the dog, that's so terrible, that should be larceny, right? It really is, or I don't know, because it's a dog, I'm all confused now. Animals, don't love them, don't hate them, don't get involved with them emotionally on the bar exam. And D, unreasonably mistaking George's car for his own. Defendant got in George's car to a parking lot and drove it home. What kind of crime is larceny? It's on our mnemonic, right? Our L on our mnemonic, laugh. On our specific intent crimes, it is in fact a specific intent crime. And what's a defense to a specific intent crime? Any mistake, no matter how redonkulous that mistake might be. Therefore, defendant cannot be guilty of larceny in D, even if it's an unreasonable mistake. Correct answer again is C. All right, guys, let's talk a little about embezzlement. Our rule is the fraudulent conversion of property of another. The fraudulent conversion of property of another. A couple notes for the MBE, some things to look out for. A, the embezzler always has lawful possession, followed by an illegal conversion. Embezzler always has lawful possession, followed by an illegal conversion. B, this is what to look out for, a trustee. It's often the MB embezzler. A trustee, someone looking over a trust, often the MB embezzler. And C, you don't have to carry away to be the embezzler, it's just a lawful possession. You don't have to carry away. And D, the embezzler doesn't have to get the benefit. The embezzler does not have to get the benefit. Watch out for something that might appear, such as hypo number 21. Trustee takes money from the trust for the specific purpose of donating it to charity. How nice. And in fact, the trustee does donate all the money to charity. Question, is the trustee guilty of embezzlement? Answer, yep, guilty. Why? Because the embezzler does not have to get the benefit. The embezzler does not have to get the benefit. Watch out for the trustee as your MBE embezzler. C, false pretenses. The third of our 3 common law property crimes. Our rule. False pretense when defendant persuades the owner of property to convey title by false pretense. To convey title by false pretense, also sometimes called false representation. 2, notes for the MBE. A, it is the conveyance of title. That is the center of false pretense, the title, the conveyance of title. B, this false representation could be as to a present or past fact. This false representation can be present or past fact. And C, a false promise to do something in the future cannot ground liability for false pretenses. Must be present or past, but not in the future. And 3, oftentimes you get a question, they ask you to distinguish larceny by trick. Here's what you need to know. If only possession if only possession of the property is obtained, the offense is larceny by trick. If title is obtained, the offense is false pretenses. Possession versus title. If it's only possession, larceny by trick. All right, guys, that jumps us to D, robbery. Having finished our 3 common law property crimes, robbery sure to be on the exam in some way, shape, or form. Great fodder for the MBE. Also great fodder for essays, so watch out for it. Here is our common law rule, robbery. Taking personal property of another from the other person's presence by force or threat. Force or threat with the intent to permanently deprive him of it. Force or threat of the person's presence. 2, notes for the MBE, things to look out for, things that popped up in the past. A, the presence requirement is very broadly drawn. The presence requirement is very broadly drawn. And would even cover a farmer who's tied up in his barn and taking things from his house. B, as for taking either by force or threat, things such as ripping a necklace from a person's neck is sufficient. And C, the threat, hey, give me your money, I'm going to kill you. It must be a threat of imminent harm. And C, the threat must be a threat of imminent harm. Let's flesh this out a little bit with a couple hypotheticals. First, hypo number 22. Lumberg goes into Milton's office and says, yeah, I'm going to need you to come in this weekend, finish those T reports. Milton replies by saying, yes, but when my staple back, and you know, so if you don't give me $500 by next Monday, I will beat you and burn your office to the ground. Question. With what crimes can Milton be properly charged and convicted? A, robbery. B, attempted robbery. C, both attempted robbery and robbery. Or D, neither attempted robbery nor robbery. What is the best answer? Correct answer here is D. Neither. Why not? Because there's no imminent harm. Threat must be a threat of imminent harm. If Milton says, give me your money or I'll beat you up, burn the office to the ground on Monday, that's not imminent harm. Now Milton, of course, would be guilty of another crime, which we'll get to in just a second, but watch out for the imminent harm testing on that element when dealing with robbery. Hypo number 23, again, correct answer there, D, neither attempted robbery nor robbery. Hypo number 23. Chuckster needs money to support his gambling habit. While riding the subway to the dog track, Chuckster intentionally picks the pocket of Rex, taking Rex's wallet. Chuckster later used the money in the wallet to bet the dog races. Question: is Chuckster guilty of robbery? Answer: no, he's not. Why? There's no taking by force or threat here. If someone's a pickpocket and you're not aware that they're taking their actual wallet, whatever it might be, then there can necessarily be no taking by force or threat, and therefore no robbery. Watch out for the pickpockets. Hype number 24. Carl's walking down the street with his hand in a paper bag. As Lenny approaches from the opposite direction, Carl stops Lenny and pushes the paper bag into Lenny's ribs. "I've got a gun here. Give me all your money or I'll shoot you." Carl grabs the money. He's arrested 2 blocks later by a nearby officer who discovers Carl did not have a gun in the paper sack, but was using his finger to poke Lenny in the ribs. Question: is Carl guilty of armed robbery? I think it's clear here, guilty of the robbery, correct? What we're testing here now is the armed portion of the robbery, and the answer here is yes. A common law answer is yes. This is what's known as the simulated deadly weapon hypo. The simulated deadly weapon hypo. Not true in all jurisdictions, by the way, not true in every state, but for our purposes, for the MBE, is true. Simulated deadly weapon is enough for armed robbery. And guys, watch out for this as well. Guy walks into a bank wearing a backpack, slides a note to the teller, says, "I have a bomb in my backpack and I'm going to blow up the place unless you give me all the money you have." Is this person guilty of armed robbery even if there is no bomb in the backpack? And the answer is yes. This qualifies also as a simulated deadly weapon. So watch out for that in the MBE. E, extortion. In lay terms, extortion is blackmail. Extortion is blackmail in lay terms. Our specific and precise rule, though, in 1, what is extortion? Knowingly seeking to obtain property or services by means of a future threat. Knowingly seeking to obtain property or services by means of a future threat. 2, differences between extortion and robbery, which they often will ask you the difference between, or is this crime extortion, is it robbery? A, you don't have to take anything from the person or his presence to be extortion. And B, the threats are of future harm, not imminent harm. Extortion, future harm, not imminent harm. And this harkens back to our hypo number 22 with Lumberg and Milton. Milton, of course, here would be guilty of the extortion. And F, forgery. Here is our rule for forgery. Is the making or altering of a false writing with intent to defraud. Making or altering a false writing with intent to defraud. And 2, notes. Any writing that has, and here's the key phrase here when we're dealing with forgery, any writing that has apparent legal significance is subject to the crime of forgery. Any writing has apparent legal significance, key phrase there, subject to the crime of forgery. All right, guys, that jumps us to Roman numeral 10, our offenses against habitation. A couple things that we're going to talk about here, burglary and arson. Let's start with burglary. Why? Because it's first in our outline. Burglary, here's our rule. It's the breaking, entering, dwelling of another at night with the intent to commit a felony therein. Breaking, entering, the dwelling of another at night, the intent to commit a felony therein. A couple notes for the MBE. I've basically gone through and broken down all the elements because burglary, like many things, sure to be on the exam in some form. Again, great for MBE, great fodder also for essays. So breaking down each of the elements and giving you a little bit of what to look out for here. let's start with 2A, the breaking element. Breaking can be actual, which means involving some force, however slight, or constructive. Actual or constructive. A1, double stars here, actual breakings. They love this one on the MBE. Watch out for this. It is not an actual breaking for someone to come uninvited through a wide open door or window. Not an actual breaking for someone to come uninvited through a wide open door or window. If it's wide open, there is no breaking, but, big but, they love to test you on this little nuance to the rule. If someone pushes open an interior door to the bedroom or living room, then the breaking exists. So here's a quick scenario. It's nighttime. I'm looking for a house to break into, to steal a bunch of stuff. I'm walking down the neighborhood and I see that the back door of this house is ajar. Well, I slide through this opening and don't touch the door, go get a bunch of stuff and I steal it and I walk back out, don't touch the door. Have I committed common law burglary? And the answer is no, because why? There's no breaking. But what they love to test you on, same scenario, I'm walking down the street, see this back door, it's ajar. I slide through, I don't touch anything. I go inside the house, but then I push open an interior door, such as a bedroom. If I push that door open, now I have that constitutes a breaking for purposes of common law burglary. Watch out for those little distinctions because they love to test you on them. 2. As far as constructive breakings are concerned, what is it? It's a breaking by fraud or threat. By fraud or threat, and they also like this one best illustrated by hypo number 25. Hypo number 25, Marcia gives a house key to her maid Alice. So Alice can come to the house and clean once a week. Alice uses the key to come to the house at 2 a.m. with friends to party. Question, is this a breaking for purposes of common law burglary? Answer, yes it is, because it's by fraud. It's a constructive breaking. That's not the purpose. She got the key. Love this one on the bar exam too, so watch out for it. And just so we know, guys, is she guilty of common law burglary? Probably not. But the question asks, is this a breaking for purpose of common law burglary? And sometimes they will do that. Just test you on one specific element or another subject, one specific part of the rule. B, entering. The thing you really need to know here, they test you on entering occurs when any part of the body crosses into the house. Any part of the body crosses into the house. The hand through the window, grabbing on, once the window is jimmied open, right? Because wide open doesn't count for breaking, but once it's a breaking, the hand reaching in, grabbing the jewels out of the bedroom. C, dwelling house of another, as far as this particular element is concerned, cannot be a barn or a commercial structure. It's got to be the dwelling house of another. Watch out for the barn, commercial structure. Of course, every state has changed this as far as at least the commercial structure is concerned. But a common law could not be a barn or a commercial structure. And D, at night, common law had to be at night. All right, guys, spend a little bit of time here. Double stars on E, double stars here, with the intent to commit a felony therein. The intent to commit the felony must exist at the time of the breaking and entering, or it is not common law burglary. The intent to commit the felony must exist at the time of the breaking and entering, or it is not common law burglary. Which jumps us to hypo number 26. Will breaks into Sue's house. Remember, facts matter, facts matter, facts matter. All right, guys, that brings us to the end of the substantive part of the lecture, but I do have just about another 5 minutes and 33 seconds left on some key points regarding criminal law. So on the next page, 2 pages of lines you can write in some general notes, tips, hot topics, strategies. Hang with me for another few minutes. We'll get you guys out of here so you can go and study. Look, guys, hot topics in criminal law, things that you need to know that show up again and again, that it's going to be on the exam. Mental states of crimes, especially the specific intent crimes. Students can always take a lap, even for ridiculous bar facts. Mental states. You got to know mental states. Transfer intent on the exam 2/3 of the time. They like to question you here, remember, on 2 crimes. Why? Because 2 victims. Transferred intent. Accomplice liability. It's going to be on the exam. They live on the MBE, but most states also for criminal law essays like to incorporate accomplice liability to have multiple players involved, right? And we know our rule. We know our rule for accomplice liability, right? It's not shovel, whisper, fist pump, right? Aid, advise, encourage. Aid, advise, encourage, right? Our rule for accomplice liability. Mistake of fact. One of their all-time favorites. Mistake of fact. One of their all-time favorites. Which is why it's important, again, to know what are specific intent crimes. Because if it's a specific intent crime, then an unreasonable mistake of fact is in play. Just homicide crimes in general, because they, in fact, do love dead bodies. They're going to be all over, scattered throughout the bar exam. But in particular, and we double star this, but defenses to felony murder. Know your defenses to felony murder. As we saw with Brad and Angelina in our hypo, make sure you peel back the layers to see really what's going on. Anytime you see someone that's intoxicated, always think this has got to be a specific intent crime. And just as an aside, guys, you know, it's not just alcohol. It could even be prescription meds. The good thing is if they say this, they'll say, you know, Frank, taking all these prescription meds, felt really woozy and out of it. And so you'll know, but it can qualify the voluntary intoxication, not just alcohol, can qualify being prescription meds. And of course, you know, robbery, burglary, sure to be on the exam in some way, shape, or form. Okay, guys, here's just a couple, the time we have left, tips and strategies. Look, reasonable belief is a key phrase in criminal law, and it applies to certain defenses, right? So if we can kind of group those together, it might help us memorialize it a little bit better. So one needs a reasonable belief for these defenses. Reasonable belief for these defenses. Self-defense, whether it's deadly force or non-deadly force. Self-defense, duress, necessity, and mistake of fact. Self-defense, deadly or non-deadly. Duress, necessity, and mistake of fact. Has to be reasonable for mistake of fact. If what? It's a malice or general intent crime, right? That's when our reasonability kicks in. Look for trigger words, guys. Look for trigger words, okay? Because they do this a lot. They'll have trigger words that make you think about something. So, for example, if you see the word trapped or the word confined, whether it be MBE or on essays, the word trapped or confined, think false imprisonment. If they test you on false imprisonment, one of those 2 words will be there. Guaranteed. So look for it. Look for our trigger phrases or words. If someone's touched in some way, think battery. If someone is touched in some way, think battery. And if someone is fearful, think assault. Someone's fearful, think assault. All right, guys, I have just two last very important points to the lecture on criminal law. Look, there's enough information in all of these books, but criminal law as well, to choke a herd of elephants, right? To digest all this stuff is crazy. So I didn't mention every single thing that could possibly be on the exam. What I do is, as all bar professors come in and do, is I give you the foundation, the things that are most often tested, the things you're most likely to see. That doesn't mean that they can't ask you about something else. I mean, sometimes they do, right? But start here. Start with this outline, knowing these things, have that base, and then go back to the bigger outline to fill in some points. But if you know these things, you're going to, have most of it down, the things that they could possibly ask you. And the things I didn't talk about, for example, I didn't talk about receipt of stolen property as a crime, okay? We didn't talk about that. So if you had to think about it, what would that be, right? What would the crime of receipt of stolen property be? Well, throw a mental state in there. What mental state do you think it would be? Negligently? Probably for that crime, probably need like knowingly. So knowingly receiving stolen property. That's the crime of receipt of stolen property, right? So again, common sense can carry you far. Start here. Learn all this. You're in a really good place. Go back and fill in with the rest of the grander, bigger outline. And the last thing I'm going to say, which in my opinion is the most important thing that I'm going to say in today's lecture, and that is one thing. There is one thing that will determine your success in large part on this exam. One thing. And that is your mental state. The story you tell about your life is the story your life becomes. So start telling your story. Be determined that you are going to pass this. Your will is your greatest strength. That's why we put another word on that. Willpower. Be determined every step of the way. Whether you think you can, you think you can't, you're right. Abraham Lincoln. Remember that. Your mental state will carry you. You guys are smart enough to get in law school, smart enough to get out, smart enough to pass the bar exam. Good luck, everyone. Happy passing. Good luck.